Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. I'd like to thank counsel for your willingness to appear by video teleconference. Let me just remind counsel and the court, for that matter, that this is being live streamed, and it is also being recorded and archived and will be available to the public. Your microphones may be on at any given moment, and your cameras certainly will be on throughout the proceedings. I and the rest of the court are grateful to the Office of the Clerk for having set up this video conference system that allows the parties before us to be heard in as robust a manner as we are able to provide, given the unfortunate circumstances of the worldwide COVID-19 pandemic. The rules are the same as they are in the courtroom, which is to say 15 minutes per side, and there is no rebuttal. Our first case this morning is number 18-1072, John Doe number 320727 versus the Sex Offender Registry Board. And we will hear first from you, Ms. Hernandez.
Good morning. May it please the court, Attorney Xiomara Hernandez for the plaintiff appellant John Doe. As you know, the Sex Offender Registry Board classified my client as a level 2 sex offender for acts he committed about a decade ago. I'm here today requesting that this court either lower my client's classification level or remand the case back to the board for another classification hearing. The hearing examiner committed multiple errors in the application of the regulatory factors, specifically 3 errors. The first error is that the hearing examiner erroneously only gave minimal risk mitigating weight to factor 32, which is the sex offender treatment factor, because my client had only recently enrolled in sex offender treatment. However, my client was released from incarceration on January 2017, and he enrolled a month later. The factor does not require for it to be applicable for the offender to be enrolled for any specific period of time.
Actually, doesn't the factor account for different levels of time? Seems to suggest that completion of sex offender treatment, it should be rated higher than signing up the day before the hearing. I mean, isn't that what your client signed up for treatment? He didn't do any in jail, and he signed up literally 2 days before the hearing.
He did not do any treatment in jail. Again, he was released from incarceration in January 2017, and he enrolled within a month later, and the hearing took place within a month later as well.
So was there no, so you mean one of the things you say, another factor you say we should take in consideration is that he participated in programming such as Able Minds and one other. Was there not sex offender programming available in prison?
You know, I didn't handle his hearing, so I'm not sure if Gardner has sex offender treatment. I'm actually not sure about that. I'm not sure why he wouldn't, if they did have it, why he wouldn't enroll in it. He does feel, extreme remorse for what he's done. He's admitted to it. So that's something that I would think he would want to enroll in. But again, I don't know if Gardner actually offered the treatment. But given the fact that he did attend, I believe it was the 2 meetings at that point, I would suggest that the hearing examiner should have given my client full credit for this risk mitigating factor.
But I'm sorry, I still don't get it. Like he actually, on one day, he went to an intake and 1 group hearing.
Yes.
Why should that be the same as somebody who completes a whole treatment program?
Well, he just got out, so he didn't have the time to complete it. So, and he has no control over when the hearing was scheduled. So had the hearing been scheduled, let's say a year or 2 after he was released from incarceration, then that would be unfair for him not to get full credit now, because he did enroll soon after he was released from incarceration.
Even if there's no blame here, let's say there was no available treatment at Gardner, and he enrolled within a month. Still, why should he get full credit for this when he's only just begun?
Again, because it was something that wasn't within his control. He doesn't have control of when the hearing is scheduled. The board decides that, and they decided to schedule the hearing within a month of him being released. That's not enough time for him to enroll and also complete treatment. And additionally, the hearing examiner erroneously failed to give full risk mitigating weight to factor 33, which is the home situation and support systems. As you'll see in the record, my client was able to get multiple letters of support from friends and also a pastor of the church that he belongs to. And in the letters, the authors actually do write that they're familiar with him, that they know of his offending behavior, nonetheless chose to support him. And I would submit that the reason why the hearing examiner gave for not giving this risk mitigating factor full credit is because the letters, he wrote that the letters were boilerplate and that the authors have a vested interest in the outcome. I would assert that those are not legitimate reasons for not giving this risk mitigating credit full weight to this risk mitigating factor. Again, there's no requirement within the factor of how the letters have to be written. And you would, I guess every writer of a support letter would have a vested interest in the outcome because they're friends or they're family members or they're connected somehow.
Don't you think, can I ask you, don't you think that a hearing, it's within the hearing examiner's discretion to say a handwritten letter in the person's own words carries more weight than a letter that was typed probably by the petitioner's counsel?
Well, I would say that would be unfair if that is something that went into the determination of how much weight to give the letters, because I know I've had clients who've had family members and friends who actually cannot write. So I have crafted letters for them. I would talk to them and get the information from them, but I'm the one who types out the letters. So I think under these circumstances, it would be really unfair to give less weight to these letters because they may have been.
Put aside whether it's handwritten or typed.
Yes.
Under the job application analogy, when you hire people, don't you give more value to a letter of reference that clearly was written by the person in terms of including lots of nuanced detail about why you're recommending the person versus a boilerplate, I work with this person and I recommend them, period.
Oh, absolutely. Yes, absolutely. But in this regard, I think that characterizing it as boilerplate letters is also unfair. If you read the letters, they're not exactly the same. There's some nuances in terms of how long they've known my client for, in what context they've known him for. There is some of the similar language in terms of choosing to support him or that they all went to visit him while he was incarcerated. So there's some of that, but some, I think one person lived in Lowell, another person lived in, further eastern Mass. So it wasn't like the same exact letter with a different name on it and then signed by the author of the letter. So I disagree with that characterization that it was boilerplate. And again, there's some attorneys who do write the letters on behalf of the authors, just to make it easier because sometimes people don't have time. And again, clients have had friends and family who actually cannot write. Or cannot write in English, for instance, and I'll have to hire somebody to translate for them. And the last factor, I actually did not argue this in the brief because a case came down after I had filed the brief, and that's the case of John Doe number 22188, 96 Mass Appeals Court 738, and that deals with high risk factor 2. And I would assert that the hearing examiner should not have given this high risk factor full aggravating weight. As you know, my client was not previously discovered or confronted or investigated for any sexual allegations or charged or convicted of anything else. This is his sole sex offense. So because of that, I would assert that the hearing examiner applied this high risk factor in error.
Well, since you wasn't in your brief, and I'm not familiar off the top of my head with factor 2, what's factor 2?
So factor 2, I'm sorry, is repetitive and compulsive behavior. And there's 3 different levels you could, the hearing examiner, according to this case, could give an offender. based on if they had been previously discussed. For instance, if it's, so although there's one victim and it took place over multiple years, that would still, only be considered, it wouldn't be given full aggravating weight under this factor because my client was not discovered and confronted or investigated and had not had any previous charges or convictions for sex.
This case says that not only that in the absence of having been caught, you can't give full aggravating weight to this factor, even though someone has plenty of time to reflect on the wrongfulness of what they're doing, and they continue unabated, even in public or whatever. Is that what it says?
Yeah, so on page, let's see, 742, it says basically that there's three levels, three sort of weight.
Did you file a 16L letter to bring this?
I did not, and that was my error. I should have filed one. But it does say that. So basically, if it's a circumstance involving what my client's involved, the hearing examiner should only have applied threshold weight, so not full aggravating weight. But again, that's fair.
What's the citation? I'm sorry, if you could.
Oh yes, so it is 96 Mass Appeals Court 738 at page 742.
Keep going.
2019 case. And again, that is fair. I should have actually filed the letter as soon as I discovered that this case was handed down. So I take that. That's fair.
What's the pinpoint site?
I'm sorry.
The page is 740.
742.
Counsel, am I correct in remembering that this is the case in which I wrote a concurring opinion?
Did you? What I printed does not have a concurring opinion.
Yes, there is a concurring opinion.
Oh, there is? Okay. What I printed doesn't, I don't see one.
Judge Sullivan wrote the opinion for the court.
Okay.
Concurrence.
Don't you remember? It was 22188.
22188.
I'm sorry.
So
Go
I
ahead.
also assert that my client poses a low risk to reoffend. Again, he has no criminal record. The only thing on his record is his sex offense. And again, it's horrendous, obviously. But again, this is the only thing on his criminal record. The victim was not a stranger. It was somebody he knew and somebody he actually lived with for a short period of time. Again, it was 10 years ago. He hasn't reoffended. He has accepted responsibility for his actions. While incarcerated, he had no disciplinary reports. He was involved in multiple programs. He had visitors, and also he worked. And he will be on probation until 2024. He was in his 30s, late 30s when he committed the sex offense. Now he's in his late 40s. He is involved in sex offender treatment.
It doesn't really make any difference, does it?
Which part?
Being in your late 40s.
Age.
I mean, age is the factor, but I've never heard anyone say that someone's libido declines in a relevant way at age 47.
So under the factors, it makes the hearing examiner did give this minimal weight, which I think was fair because, he hadn't turned 50 yet or 60 yet, and the victim was a child. So I think, giving it really low risk mitigating weight was fair under these circumstances. And again, he is in a supportive home environment with the support of many friends and his pastor. He does continue to go to church.
I'm sorry, I've got a question for you.
Yes.
You say in your brief a couple of times that the Department of Correction assessed his risk of reoffense as being low. You cite our record, page 20. I don't see anything where there's an assessment by DOC. Could you point me where that is?
So I think the reason why actually I'm not even arguing that today is because I actually didn't find a better site. This site, I think, is his attorney who asserts that, but there's really not much in the record to really confirm it. So that's one reason why I'm actually not even arguing that today. So lastly, I would request that this court remand the case back to the hearing examiner because, as you know, the hearing examiner did fail to make any findings that the public interest would benefit from my client's information being publicized on the internet. Again, the victim, it was one victim, and it was somebody he was familiar with, actually somebody he lived. And again, it was just one sex offense. So for these reasons, I request
Can I ask one question? I'm now
Sure.
looking at the report.
Yes,
In factor 2,
yes,
the examiner does not say that he or she gives it full aggravating weight. It just says the petitioner had ample opportunity to reflect on the wrongfulness of his actions and indeed apologized to the victim's brother at one point during the period of time and continued to offend. Therefore, I find this factor is applicable and give it aggravating weight. Is that an error under this new decision?
I actually had another case, actually that I argued 2 days ago, where the Superior Court judge found that that language, aggravating weight, even though the hearing examiner did not put the word full in front of it, actually indicated that the hearing examiner, in fact, gave it full aggravating weight. You know, at best, it's unclear. I would assert that it's just the way I read it. It sounds to me like the hearing examiner did give that factor full aggravating weight. Again, it's unclear, but that's the way I would have read it.
Well, I do see another one that says it's some mitigating weight, and I see
Yes.
one that says increased aggravating weight.
Yes,
Excuse me.
bless you.
Yeah, we'll ask your brother about this, I'm sure.
Okay. If there's
But
no
isn't this case different from the one that you've now cited, in that aside from the mere passage of time, there was an affirmative acknowledgement by him that what he was doing was wrong, and therefore you don't have to rely on the mere passage of time?
I'm sorry, for what factor?
Factor 2.
What do you mean mere passage of time? He
Sorb has an interpretation that the mere passage of time is the time to reflect is
Yes.
enough to satisfy the compulsive aspects.
Yes, but
What
again,
the concurrence was about, whether that was sufficient. But what I'm saying is here, do we even have to go there if in fact there was affirmative evidence that he had thought about it and knew that what he was doing was wrong?
well, my argument is that this factor does apply. However, the hearing examiner should not have given it full aggravating weight because he was not discovered and confronted or investigated. He wasn't charged or convicted of another sex offense. So that's what I would assert.
So you're relying essentially only on the majority in that case,
I am.
and not the concurrence, which you may or may not have read at this point.
I actually didn't read it when I printed it. It didn't come out. The program I have did not print the concurring. I guess I'll have to go back and read it. And if
All
there's
right.
no further
Yeah.
questions, I'll rest on my
Now
brief.
your time has expired. Thank you very much.
Thank
Excellent
you.
argument. We will hear now from you, Mr. Grogan.
Thank you, Justice. Just wait for the clock. There we go. May it please the court, Patrick Grogan on behalf of the board. Substantial evidence supports the level 2 finding. I'll start right with factor 2. Factor 2 is applicable and it was properly applied in this case. What I'll point out is that you often see in board hearings that factor 2 is applied either as applicable or aggravating weight, moderate weight, which is when you've been caught and then you continue to reoffend without a conviction, and then the highest or full weight, which is what that case determines if you've been caught, sanctioned by a court, convicted, and then did it again.
Is that in the regulation or only in the decision? Okay, I see.
Yep. The hearing, the words regarding moderate, and it doesn't specifically say that in the regulation. What it does say is the least amount of weight is given for somebody who's had an opportunity to reflect on the wrongfulness, yet continues to reoffend. Then the more weight is given when you're sanctioned or caught, and then
So
you do it again.
the fact that the hearing examiner used that language of the whatever the threshold weight in the determination of how much in the discussion of that aggravating factor, you think implies that only that threshold weight was given?
It's explicitly stated. And the reason I say that is because factors 1 through 24 are aggravating factors. They're factors that aggravate the risk for an offender. Factors 1 through 6 are statutory high risk factors. Factors 7 through 24 are risk elevating factors. So all those factors, if applicable, aggravate an offender's risk. So the fact that he didn't say that he gave moderate weight and the fact that he refused to give full weight shows that he properly applied it pursuant to the factor. Now, there are a number of other factors that apply. I don't think they're really in contention here, but we do have another statutory high-risk factor that applies. At the onset of the offending, the child was a prepubescent 11-year-old child. So factor 3, again, a statutory high-risk factor applies. Factor 7 applies because they're extrafamilial.
On that factor, that's the one factor that he gives increased aggravating weight to.
Because she was prepubescent at the onset. And if you read the factor, that's when you can give increased weight to it. And thank you, Justice Massey. I think that strengthens the point that I was making earlier, where he specifically wrote increased weight under factor 3. Again, both statutory high-risk factors. Also, in this case, an aggravating factor is factor 19 because these are digital penetration offenses. Regarding the mitigating factors, they were properly applied. Easily is factor 30 because, as the factor itself states, the risk of reoffense decreases with time. Specifically for a child molester, it's over the age of 60. So he was given, in an abundance of fairness, some mitigating weight for that. Regarding sex offender treatment, the factor explicitly states that. The purpose of the factor is to recognize the mitigating effect of participating in and completing treatment. That's why you get full weight if you complete it. Signing up 2 days.
Mr. Grogan, do you know whether treatment was available where he was incarcerated?
It's beyond the record, but Gardner does have a treatment program for the beginning stages, and where somebody got a 7-year sentence, if he wanted to do treatment, he could have transferred to the treatment center.
This isn't in the record. The failure to do treatment isn't relied on by the hearing examiner in this case, right?
Correct.
Let's not.
In fact, he gets the credit under factor 30. Sorry.
No.
In fact, he gets the credit under factor 32, but he shouldn't get significant credit for it. Again, I mean, he couldn't have gotten that much benefit from his intake and his one group meeting. So, but he was still given credit for it because he did, once he got out of prison, did start treatment. So he gets some mitigating weight for that. Factor 33, again, the hearing examiner did this properly. I can't stress enough that it's the purview of the hearing examiner to weight the evidence. And if you read these letters, they really don't get much more form than these letters. And I have to point out that the only differences in these letters, besides the names, would be the amount of time that they knew the offender, and pretty much that's it. You'll see, I am X. I have known the offender since however long. It's important at this point to note that every single letter that I read, and I think all of them, I can say that safely, all knew him before the onset of the sexual offending, and then knew him during the sexual offending, and of course know him after the sexual offending. The purpose of factor 3 is pretty clear, and if you read it, it says the board shall give greater mitigating consideration to evidence of a support network that is aware of the sex offender's history and provides guidance, supervision, and support or rehabilitation. That is nowhere in these letters. What it says is, yes, I'll help him. Other people will too. That's what every single letter says. So for the hearing examiner to say, I have these letters, I will give him credit for it, but I'm going to lessen the mitigating weight for it, is directly under the purview of the hearing examiner, and was proper in this case. He actually even got credit for factor 34, which is stability in the community. He wasn't really in the community for about, I think, a month and a half before we had the hearing, but he got credit. He got a lot of credit that inures to the benefit of the petitioner. Now, regarding the issue of remand, this court is well aware of the holding in 496501. And specifically, I would point to pinpoint site page 655 of 496501, that it states, internet dissemination for sexually violent offenders almost invariably serves public safety interest. In this case, we have a repeat over 2 years contact offender on a prepubescent child. Those facts alone support a finding that internet is appropriate, but also looking at the application of the factors and using the analysis that was done in 496501 and later in 23656, you can see the breakdown of the factors supports a level 2. I would like to point out here that he initially was pre-classed as level 3, but after the hearing and after the mitigating weight, he came out at level 2. Factor 2 and factor 3, two statutory high-risk factors, specifically speak of the risk of reoffense. Repetitive and compulsive, and the fact that he targeted a child who was prepubescent does that. Extrafamilial as well strengthened that argument. The fact that it's an extrafamilial victim, his victim pool is significantly increased by that. And then factor 16. Factor 16 is the factor of doing something where discovery is likely. That one highlights the compulsivity of an individual who can't control his urges and will actually take risky chances of sexually offending when it can be detected by other individuals. He repeatedly did things in front of the brother in this case. And the brother at the time was 2 years younger than the victim, so ranged from approximately 7 to 9 years old at the time. There's a very likelihood of reoffense when that kind of compulsivity is driving the sexual offending. Looking at the danger should be pretty clear just on the facts and circumstances of this case, but two factors specifically highlight that. Obviously, factor 3, which is an adult offending on a prepubescent child, as well as factor 19, a level of physical contact. The potential harm were he to reoffend again on a prepubescent child with a digital penetration offense is pretty clear from this. Pursuant to the holding of 496501, I would urge you to follow that and see ultimately in this case that the facts so clearly dictate on this individual that internet availability of his information is appropriate. Based on that, there was no error regarding application of the factors, and a remand isn't necessary on these particular facts, unless there are any further questions.
I have a
Yes,
question. What do the regs currently provide for seeking reclassification after the passage of time? You know, suppose you know suppose he did, you know, he's been suppose he, you know, the last 3 years. This is an old case. You know, the hearing was about 3 years ago. It was more than 3 years ago. So what is the current time frame for that? For
3 years. He could file for reclass.
Okay.
Yes, he could. And the no case provides that were he indigent, although I don't know from this record, obviously 3 years, he would be provided an attorney and the burden remains with the board for clear and convincing evidence. So he could file for a petition for reclass, I believe today.
I've got two questions. One is, with the still relatively recent statutory changes, is there much practical difference between a level 2 classification and a level 3?
I mean, realistically, you have active dissemination on a level 3 where you have posting of the picture, as well as schools being informed and other places that potentially for a child could be there. It is true that with the advent of the internet, it's easier for individuals to get information regarding a factor 2, but there still is additional, I believe there's posting in the post office, there's posting at the schools. The police actually do actively disseminate his information to target areas such as where children might be found.
Yeah. And my second question is it fair to assume that the board's thinking about factor 2 has not changed in spite of the brilliant concurring opinion in the SORB case that has a lot of 2s in it?
Well, I'm familiar with your concurring opinion. I did read it, Justice Milkey. What I would point on that is the way that I deal with factor 2, and I think it's clear from the way the factor is broken down and the research supporting the factor, that what happens is when an individual has an opportunity to reflect on the wrongfulness of his actions, yet, and this is how I word it when I write my oppositions, compulsively continues to do it. The point of the compulsivity of it is the fact that he's had the opportunity to reflect on how it is wrong, what he's doing. And in this case, as you pointed out earlier, he actually said something to the brother about how he knew it was wrong. So he knew this was something wrong, yet he compulsively continued to sexually offend against the child. I would also point out, go ahead.
But that goes to whether or not we have to reach the issue in this case. I'm asking a more general, perhaps impertinent question about whether or not the board's position that the mere passage of time is enough to show compulsivity has changed.
I have never argued that it's just mere time. It's mere time of reflecting on the wrongfulness, yet compulsively doing it again. Any single time, if you have evidence of somebody who's done it over a protracted period of time, had that opportunity, yet knowing it's wrong, sexually reoffends. It's been my position as an attorney on the board that highlights the compulsivity under factor 2. I think in this case as well, you don't have to reach it, as you had mentioned in your questioning earlier. And I'd also point out that I would suggest factor 16 also highlights the compulsivity with this offender, because again, he did it in front of another child that could detect him and report him. Now, again, unless there are no further questions, I would rest on my brief.
Seeing none, thank you very much. Another excellent argument. The case is submitted.
Thank you.
Thank you.
We're all set.
Good morning. Welcome to the Appeals Court. I am Justice Rubin, and I'm joined today by Justices Milkey and Massing. The rules are as they are in the courtroom, 15 minutes per side, and there is no rebuttal. I would remind counsel that we're doing this by video conference, which is streaming live and which will be archived, recorded and archived. And you should be aware that your microphones may be on at any time and your cameras will be on throughout the proceeding. The next case we will hear is number 19-778, Spagnolo versus Holzberg. And we will hear first from Ms. Manning.
Good morning. Good morning, Justices. I apologize for the glitch earlier. May it please the court, I'm Mary Ellen Manning, and I represent Edward Holzberg, an attorney, a solo practitioner who practices up in Danvers, Massachusetts. This case was a emotional distress and sexual harassment case that was filed by his longtime secretary and resulted in nearly $250,000 judgment against Mr. Holzberg. And I'm not going to sugarcoat the allegations that were made against my client. The allegations of, the assertions about what he had said were statements that were verbally abusive, statements that were disgusting, despicable, actionable, and compensable in workers' compensation, not in a court of general jurisdiction. I know that you've read my brief, and in that brief, you'll see that there were multiple times where we made the argument based upon the exclusivity provisions of workers' compensation, as well as the case law, starting with Green versus Wyman, Gordon, and the estate of Stephanie Moulton versus Puopolo. In those cases, it's very clear that employees who are injured at the hands of their employers, even if it's intentional and despicable and wanton, even if it's sexual harassment, that those injuries must be compensated and remedied in workers' compensation. We argue this at a motion to dismiss. Judge Fahey ruled against us, and then that became the law of the case. And she relied on a case called O'Connell versus Casdy, which was cited by my brother. And that case had to do with a sexual harassment claim where two employees had left for an international business trip. And one of the employees was sexually assaulted by one of the other employees. That's an employee-on-employee sexual assault or sexual harassment case. That's not an employer on an employee case. But as a result of Judge Fahey's ruling, each and every judge after that, Judge Lang, at a subsequent motion to dismiss, which was treated as a motion for summary judgment, said that Judge Fahey's ruling was the law of the case. Just Judge Howe, after that, at a motion for summary judgment, also relied on that same ruling. Judge Lang again relied on that ruling for the jury instructions and motions in limine that were argued prior to trial. And the jury was instructed on both sets of claims. Now, they were instructed on the intentional infliction of emotional distress claim, which we say should have been held before a court, before the Department of Industrial Accidents under the Workers' Compensation Act. And they were also instructed under Chapter 214, Section 1C, which is the sexual harassment statute.
Can I ask you about
Yes,
the Section 1C claim? I couldn't find any place where any judge explicitly said it's O'Connell that bars, that means that workers' comp isn't exclusive with respect to the 1C claim, because I thought Judge Lang sort of missed that, at least in the second motion to dismiss opinion. Am I right that no one expressly says either I'm following Judge Fahey and doing that, or that's my independent conclusion?
If I interpret you correctly, Justice Rubin, Justice Lang came out and said what Judge Lang came out and said that what Judge Fahey had decided in the dismissal was the law of the case.
Yes, but her
He
dismissal couldn't have applied to the 1C claim because it was added after. So I'm asking if anyone ever explicitly said, I understand they, in denying the motion, they implicitly must have said, but that's without any reasoning. Did anyone say O'Connell or Judge Fahey's ruling is the reason that exclusivity doesn't apply to the 1C?
I'm trying to remember. I don't recall seeing that, Your Honor.
Okay.
I think that the closest I can come to that is that Judge Lang said he didn't believe that as an after reading the Lowry versus Clem case, which is another avenue of error here, that he didn't see any difference in Chapter 114, Section C, in treating an employee versus an independent contractor. To him, it didn't matter at all whether Ms. Spagnolo was an independent contractor or an employee. He allowed it to go forward. Does that answer your question, Justice Rubin?
I think so.
All right. If I can do better, I will.
No, it's not. I'm just wondering. I was just wondering if there was any. Judge Fahey's isn't the law of the case with respect to 1C, but whatever. Your motion to dismiss clearly raised that ground and was denied. So
there's I'm finding on there's a Justice Howe's summary judgment decision. She mentions it at pages record 83 and 84, although exactly the basis I can't quite tell.
Yes, I think that's correct. I think that's correct, Justice. Did you have a question, sir? Justice Massing, did you have a question?
Absolutely. I didn't, but I do. So, I mean, just to be clear, you're saying that the workers' comp exclusivity law is very confusing. And, I can see it's easier to get to the intentional infliction, but you're also saying that sexual harassment claims are solely the province of workers' comp. Wouldn't that mean there be no possible sexual harassment claims?
That's not what I'm saying, respectfully. The portion of the sexual harassment claim that can be tagged to emotional distress cannot be recovered twice. So if an employee wanted to go forward with the emotional distress claims arising out of sexual harassment, that the emotional distress claims would have to go forward in workers' comp. That would be the $20,000 that she got for emotional distress, plus the $20,000 that she got for emotional distress under under the 214 Section 1C, plus the constructive discharge under 214 Section 1C, because that's also compensable under workers' compensation. She would be allowed to go forward under any other theory of injury, such as economic damage or punitive damages. She would be allowed to go forward under punitive damages, I believe, Your Honor. She doesn't need to have compensable damages in order to, under Massachusetts law, I don't believe, to go forward with punitive damages. So she can go forward.
Wait, so in this case, the punitive damages were how much?
$150,000.
And on this ground, the exclusivity provision, you're not challenging those.
I don't believe that workers' compensation covers punitive damages. I will say, though, that in the event of an employer committing an intentional tort, which is what's alleged here, under Section 28 of the Workers' Compensation Act, an employee can get double damages. So query whether that would actually be the punishment that would be involved. And back to Justice Massing, the sexual harassment claims that are perpetrated by fellow coworkers, those would always be able to be pursued under 214 Section 1C when there are fewer than 5 or 6 employees.
Can I
It-
ask a
we would
question
only-
about
Yes, sir.
this coworker-employer line?
Yes.
So, as I understand O'Connell, and I've read all the cases you've cited, this seems like a morass to me. I find it almost incomprehensible where these lines are. But they treated the director, in O'Connell itself, the director of the charity for whom, I guess it was O'Connell, worked, as a co-worker, even though that person was the director, which I take to mean the chief executive officer, and therefore certainly her ultimate supervisor and the person who ran the operation. And because the structure of it was corporate, the employer is a corporation and the coworker is a person. It seems very odd to me to say that in a case like this, because it doesn't happen to be a corporation, that the head of it, who works with the plaintiff, can't sue. But if this happened to be a PC or something like that, maybe she could. Do you have any thoughts?
I do think, yes, I do. I think a couple things, Your Honor. The one thing is that in those cases, that employer, that supervisor had some sort of direct tort. In other words, they either didn't investigate it properly, they didn't look into it properly, they ignored it. So there's that enhanced obligation of a supervisor to do something about it. In those cases, the corporation is not held responsible for the acts of those employers under our setting.
Mm-hmm.
In this, but I think you'd have to look to the estate of Stephanie Moulton line of cases.
Yeah.
But bless you. Where in those cases, no matter how despicable the act was, no matter how intentional the act was, even exposing somebody to toxic chemicals intentionally, if it's done by an employer, it's exclusively the jurisdiction of workers' compensation.
But you don't think it has to be in furtherance of the business interests of the employer? That is, let's say the employer was just a sadist, and his idea of a good time was seeing how long it took after exposing his worker to poison for her to lose consciousness. So every day she came to work and he would pipe some toxic fumes in, and eventually on day 7, she falls over and goes to the hospital. And it's nothing to do with their work. He's just amusing himself because he's sadistic. Is that because he happens to be the employer? She has to go to workers' comp, even though what he's doing has nothing to do with the business?
Yes, because I think that any employer, anything that an employer does is inherently in furtherance of his business, even if his idea.
What if he's exposing himself? What if how is that in furtherance? I mean, he runs a shoe company, but he's also got whatever personal problems he has that lead him to drinking, whatever, lead him to expose himself. It doesn't increase profits. It doesn't help sales. It doesn't manufacture shoes. It just offends and frightens the workers.
I think there are a string, if you were to look at and consider all of the workers' compensation cases and read what employers have been done to employees, you would find all kinds of things. The Stephanie Moulton case resulted in a murder. Many employers have punched out their employees, have gotten into brawls. It's not for us sitting here cozy in our professions to be able to determine whether or not every single thing that goes on inside the workplace is something that we think is in furtherance of their business. It's happening on the site, it's happening during work hours, and these types of things that were said to her were engagements in office banter, whether or not it was acceptable. It was office banter, and or it was very critical, very mean instruction of a worker. And those are certainly on the scale, on the spectrum of everything out there. These are more towards workplace torts than they are towards what you're talking about, Your Honor, which I believe would be, acts of terrorism inside an office, and grossly criminal acts. And quite honestly, those particular employers aren't shielded from criminal responsibility. Everything that you just talked about actually are criminal acts as well. And they are subject to criminal exposure, no pun intended, even in this setting. Thanks for the smile, Justice Massing. I'm out of time, and I really appreciate your time. I wish we could have gotten to some of the other issues, but I know you've read my briefs, and I appreciate your time, and I'm glad everybody looks well. Thank you.
Thank you very much. We will hear now from you, Mr. Hawks.
I'm sorry, Justice Rubin. I'm sorry, Mr. Hawks, too. Can I ask a couple more questions of?
Oh yeah, of course.
Manning?
Yeah.
I do have a couple of questions. Two quick questions. One is, you make an argument about no causation for the injury on the intentional infliction of emotional distress.
Right.
The negligent infliction of emotional distress charge was lost, a motion to dismiss or summary judgment or somewhere. How did the negligent, because of no causation, right? Why does the intentional survive when the negligent one didn't?
I think if I were to recall, the negligent infliction of emotional distress had to have a physical manifestation component.
Okay.
And that was not present.
Gotcha. Okay. Thank you. That's helpful. And the other question is on the counterclaim. I understand that your client was not able to make a proffer about his business at Lynn District Court. But what I don't understand is, how did the defendant counterclaim, the plaintiff's husband, what did he have to do with Lynn District Court?
My understanding is, well, there was no evidence I can't testify to that, Your Honor. There was no evidence deduced on that point. I did say at sidebar, I did have a conversation with the judge about that, but the judge did the talking.
So what evidence do we have that there was a sufficient proffer about the connection?
What the judge said to me was, I'm assuming that what you're going to say is that he doesn't want to go into Lynn District Court because he'll bump into the plaintiff there. So therefore he's given up cases and things like that. And I said, yes, Your Honor, that's correct.
That's on the record. That's on the record. But does he work at Lynn District Court? I didn't understand why you would bump into this guy at Lynn District Court. You mean just like parking in Lynn or something?
Again, Your Honor, I feel constrained because there was no evidence deduced on it, but it's my understanding he's a frequenter of Lynn District Court and he would run into him sufficiently. That was my understanding.
Okay.
And that would be not as a defendant or anything, but as a frequent visitor of Lynn District Court.
Okay. Judge Massing, do you have more? Or?
That's it. That's all. Thank you.
All right. Thank you very much, Ms. Manning. Now we will hear from you, Mr. Hart.
Thank you very much, Your Honors. So this case was well beyond any type of office banter, as my sister suggests. It was outrageous and deplorable conduct. The appellant discussing the superiority of whites versus blacks, calling blacks the worst people in the world, discussing bragging about having sex with child prostitutes do not further any legitimate business interest. They have nothing to do.
What do you do with the estate of Moulton case? How do you square that with O'Connell? I can't figure it out. It seems extremely complicated to me. How do you square those two cases?
When I look at the statute, okay, I look at chapter 214(1)(c). The Superior Court has jurisdiction to hear the sexual harassment claims. Chapter 151 provided a vehicle if he had a certain number of employees. Chapter 214 catches the case if it does not. Workers' comp is not designed for these type of claims.
I'm not asking you that. I'm asking you how you square the Moulton case. I'm not saying I would, as an original matter, find that the exclusivity provision of workers' comp stops any particular thing, but it clearly stops some intentional torts from going forward. And I'm having a hard time figuring out what they are, or why, or when they aren't.
Well, Your Honor, I think if they're intentional tort is somehow an accepted risk of doing business, then workers' comp would cover it.
Which tort is that? I mean, which tort is that?
Intentional infliction of emotional distress, Your Honor.
Can be a part of the job description?
No, I'm saying if it had been.
No, but I'm trying to.
Workers' compensation.
I'm asking, what is the universe of intentional torts that you would also say are a cost of doing business? I don't. It seems like either they should be in or out. Maybe that's wrong, though.
You're right. I can't speak to what torts are an accepted part of doing business as a law firm. I couldn't tell you. But knowing you have a sensitive, emotionally fragile employee and completely acting, as you reference, in somewhat of a sadistic manner, again, this is somebody who's a person of color that is being constantly badgered and attacked. I think, frankly, the defendant was enjoying it. There's no rational furtherance of the employment interest here, which is why workers' comp would not cover it. And it's why the court, through multiple motions to dismiss, allowed the intentional infliction of emotional distress tort to move forward.
Well, I don't know. I'm looking now at Moulton. So long as the injuries were sustained while the employee was acting in the course of her employment, as the plaintiff alleges happened here, actions for negligence, recklessness, gross negligence, and willful and wanton misconduct by an employer are precluded by the exclusive remedy provision. And then there are citations that have serious and willful misconduct by employer, intentional exposure to toxic chemicals, gross negligence. Actions against an employer under the wrongful death statute are precluded by the exclusive remedy provision of the Act. So what's the line here?
It's clear that the legislature has put in protections relative to racial discrimination and sexual harassment. What you're talking about, Your Honor, would be some sort of physical injuries that an employer perpetrated against an employee. So some sort of wrongful death, poisoning, some sort of torts like that.
Intentional. I mean, I'm sure there's a statute that prohibits intentionally poisoning anybody, right? I mean, there's got to be, just like there's a statute against harassment, there's a statute against intentionally poisoning people. No?
I agree, but where the legislature has stepped in and provided a remedy for these types of actions, and we're talking about somebody whose the intentional tort is based upon their being a protected class, in this case, sexual harassment, gender basis, racial discrimination, all these things created a hostile work environment. I would argue to this court that where the intentional tort is based upon protected classes, workers' comp is not the remedy for that. That is not the purpose of the workers' compensation exclusivity provision. Had the legislature not provided a catch-all with Chapter 214, I don't think we'd be here, but we're here, Your Honor, because these actions by Attorney Holzberg were very, very egregious, and they were done intentionally. And they were done with knowledge that the plaintiff was being treated by a therapist, and he continued to do them over her objection day in, day out. That's clear on the record. It's clear by the collateral witnesses who testified as well. As far as the question was asked about the Lynn District Court, that was, again, too far attenuated a line of inquiry. I mean, counterclaim defendant was a MBTA worker. The whole premise that he would be, at the Lynn District Court, again, the judge did not hear that because it was, too far attenuated from any actionable damages under intentional infliction of emotional distress, which was the only count that the appellant, the defendant in this case, had, Your Honor.
Isn't that usually a jury question?
I'm sorry, what's that?
Isn't that usually a jury question? Whether
It-
proximate
it-
cause.
The question of whether or not it's a jury question was not objected to by Attorney Manning prior to the instruction going to the jury. So that issue, as far as I'm concerned, she's lost the right to appeal that, Your Honor.
Wait. So then what was the purpose of her wanting to introduce that evidence?
She wanted to introduce lost damages or lost wages or business
And the
damage.
judge said these are too attenuated, meaning they're not proximately caused by anything done by your client, right?
Correct.
All right. So the judge says rules over objection. This is not, these damages can't come in. They're not proximately caused.
Because from the judge's view, the October 22nd, 2015 incident, which was the sole incident involving the counterclaim defendant, could not possibly be causally related to any business losses that he suffered.
Well, you couldn't possibly be. But for cause, couldn't it be? I mean, now maybe it's not proximately caused. Maybe it's proximately caused by irrational fear or something on the part of the of Ms. Manning's client. But if the jury believed I stopped going to district court, I mean, again, there's a question of what the proffer was. But why couldn't fear keep someone from doing all kinds of things? I don't understand that.
Because there was no rational relation to the claim. And the judge said it was too far of a stretch. And frankly, I mean, we're talking about an MBTA worker who works in the Boston area and going to the Lynn District. I mean, it doesn't even make any sense. It was
Is that in the record, what your client does and where he works?
Yes, of course. MBTA worker.
In
Correct.
Boston, though, I mean.
I believe it is, Your Honor. I don't recall.
And does he live in Lynn?
No, he lives in Peabody or Danvers.
Okay.
There was yeah. And again, they did a deposition of him. So had they had any testimony from that deposition relative to him going to the Lynn District Court on a regular basis, I'm sure my sister would have brought that up to the trial court. She did not. She made no proffer relative to that. So again, and she failed to bring that issue up before the jury instructions, the final jury instructions were provided. She didn't object to that. So it seems to me that much of the appeal goes to whether or not the punitive damages were warranted. From my point of view, I don't believe the punitive damages went far enough in this case, but they were well within the range. There were single digits. The underlying award of $20,000 for the hostile work environment was the punitive damages were 7.5 times the underlying award, which is well within the reasonable range of an acceptable ratio here. And from my point of view, there was just there's no merit to overturn that award. It's again, I mean, if you consider the totality of what was said and things were precluded from even going to the jury, for political concerns raised by my sister. I mean, these just didn't go far enough in my view, but to overturn it.
Well, let me ask you this. The second factor that the judge instructs, as the judge was allowed to do, instructs the jury to consider is the wealth of the defendant to determine what would be adequate to punish and deter, which
sure
the jury need not be instructed on, but they were. What evidence in the record is there of that question, of the wealth of the defendant?
Well, there was evidence and testimony about the defendant bragging about his airplane, bragging about his limousine, discussions about having a limousine driver, his bank records, technically, only his operating account bank records went into evidence.
What do they know? Can we infer something from them? And if so, do you know what?
Well, again, I think a jury looked at the bank records. They looked at, or they heard the testimony and evidence about the airplane and the limousine.
He owns the limousine, or he hires a limousine every day, or what was that testimony?
Yes, he owned a limousine. He had a driver. This was another area of contention between my sister and I, trying to object to this line of questioning. But yes, he had a limousine driver.
And what kind of he owned an airplane?
Well, my client testified he bragged about owning an airplane, a Cessna airplane. There was testimony about that during the trial as well.
A propeller plane.
Candidly, I don't know much about airplanes, but
okay.
I'm assuming they're not.
I would think Cessna would make both, but I don't know.
Yeah, well, sure. And so there was evidence on the record to suggest that they did consider his wealth. There was no evidence by the defendant that says he was just, broke individual who couldn't afford anything. I mean, he's clearly spent, massive amounts of money on legal fees defending this case. I think at one point my sister told the court that
but the jury doesn't know that.
Dollars on legal fees. So I mean, he had.
Yeah, but the jury doesn't know that. I hope.
No, they don't know that, but there was evidence in the record to provide insight into his wealth, Your Honor.
The video shows an office that isn't quite one international place.
No. But perhaps, I mean, it's a jury, Your Honor. I mean, it's a jury. The jury is selected from a cross-section of society. There was a lawyer from Marblehead on the jury, as I recall. I mean, there was, high net worth, low net worth people, and the jury made a decision that he had the wealth. That was one factor they considered. I mean, the reprehensibility of the behavior and the statements and the actions, I think, was the biggest factor that the jury considered. And, whether or not this is acceptable conduct in a law firm in Massachusetts in 2015 is the big issue. So wealth, I mean, one factor of multiple factors that the jury considered. Are there any other questions that you may have right now for me?
I see none. If you're all set, you still have 43 seconds, but we can wrap it up. Thank you very much, Mr. Hawks. Excellent argument on your part and on your part, Ms. Manning. And the case is submitted.
Thank you, Your Honors.
Welcome to our final case for the morning, and welcome to the appeals court. I'm Justice Rubin, and I'm joined today by Justices Milkey and Massing, and we appreciate your participation by video conference. I should say that under our standing order about video conferencing, you need not stand, but you may if you would like. This case is number 19-1407, Marculetiu versus Curtis. It is partially impounded. I don't know what the scope of the impoundment order is, but I will trust counsel not to utter impounded information in open court. I would also remind counsel we are live streaming on YouTube, and this is being recorded and will be archived. You should be aware, therefore, that your microphones may be on at any point during the proceedings, and the cameras likely will be on you consistently throughout the proceedings, even when you're not speaking. It's 15 minutes aside, my understanding, and no rebuttal. My understanding is that the appellees will be dividing their time 50-50, 7.5 minutes each. Is that your understanding as well, counsel?
Yes.
Very good. We will hear first then from Mr. Grumbach.
Thank you, Your Honor. May it please the court, I'm Jim Grumbach. I represent the plaintiff, COSMIN Marculetiu. His name is difficult to pronounce. I'd like to initially address the scope of impoundment. There was an order that certain therapist records from a therapist, Ellen Ronca, be impounded. However, Ms. Ronca testified by deposition, and her deposition is in the record, and all that was impounded.
So the transcript itself is not impounded?
Correct, Your Honor.
And the exhibits that may be impounded, I don't think are actually made it up to us. Is that correct?
Yeah, you do not have any impounded materials. Thank you. This case involves the reversal of the normal burden of proof as to liability in a civil case with respect to a defendant and insured. The two defendant insurance companies' safety is Mr. Marculetiu's homeowner's carrier, and National Casualty insures IBAN, the company founded by Mr. Marculetiu to teach ballet and encourage international dance. The two defendants refused to provide a defense to a professional dance instructor, Mr. Marculetiu, who has been targeted by a vengeful dancer, Lissa Curtis.
Can I just stop you there?
Sure.
On the CGL policy, the company is the named insurer, and if I am understanding it correctly, in the underlying tort case, they did defend the company.
IBAN, yes.
So your client's potential liability there vis-a-vis the company is limited to his role as director or officer. Is that correct?
That's correct, but he's entitled to a defense.
No, I understand that, although the company makes the threshold argument that the only possible claims that he theoretically might be liable for in that capacity would be for failure to supervise or negligent hiring, and you can't be liable for negligently hiring yourself or negligently supervising yourself. How do you respond to those thresholds?
Well, thank you, Your Honor. That relates to the negligence claim only. And there are two counts against IBAN. One is for negligence and one is for respondeat superior. The negligence count is against Mr. Marculetiu as well. But more importantly, the claims of sexual assault and rape, which occupy a great deal of the complaint, are against both Mr. Marculetiu and the company. The claims of false imprisonment and wrongful entry, which should be covered under the personal injury provisions of both policies, are specifically against Mr. Marculetiu.
No, I understand that, but that doesn't answer my question in terms of how the national would have a duty to defend your client in the limited role as manager, officer, or director.
Well, the policy specifically provides that the coverage goes to both the corporation and its managing employees, such as a director. Mr. Marculetiu is sued as a director. I don't have the citation as to the appendix right in front of me, but I don't think there's any dispute in the policy that the policy covers not only IBAN, but its directors and officers, and he's indisputably a director and officer. So I'm happy to provide Your Honor with that cite if you'd like, but otherwise
No, we can find it, assuming it's in the record.
So this is a suit, Your Honor, that was likely to cost thousands of dollars for Mr. Marculetiu to defend, and ultimately led to his filing for personal bankruptcy. He brought the DJ action to obtain a defense. The insurers both prevailed on a motion to dismiss, not summary judgment. In the meantime, the underlying case has moved along on the merits. It was supposed to start trial at the beginning of June, but because of COVID-19, it's been postponed. Mr. IBAN and Mr. Marculetiu paid the premiums, and unfortunately had the bad luck to be the target of a vengeful claimant, and he's merely seeking a defense to clear his name. Now, the complaint is far-fetched on its face. The first alleged assault was in a plane between New York and Germany.
But that's not the point, right? I mean, it could be the point if what was alleged is covered by the insurance policy, right? Even a baseless claim, of course, has to be defended. But we're trying to sort out what, if any, pieces of this are not swept up in the intentional or expected injury aspect, right? Saying that he's not liable at all, I don't think just brings it into the duty to defend, unless it's not liable at all for something covered.
Correct, but there is a burden of proof in this case, as in all cases.
Okay, but if I have car insurance and someone sues me about something that happened at work and it's a baseless claim, I don't get my car insurer to defend me because they have nothing to do with something that happens at work. It's not covered under the policy.
Correct.
So,
if the claim is that you're driving without authorization, and that's a factual question, then there has to be a duty.
all right, so what is the, give me, let's go through the counts. I don't really get this. I get some of it, but let's take a rape count.
The rape count is not covered, Judge. Let's move right to the.
Tell me, yeah, great. Tell us what counts are covered, if any.
Count for false imprisonment and negligence and breach of fiduciary duty.
Okay, so negligence seems tricky, but I want to get back to false imprisonment in a minute.
Yep.
And the reason negligence seems tricky to me is the allegation is of intentional, non-consensual sexual contact. Now, it seems to me maybe they had sexual contact and it was non-consensual. Maybe they had sexual contact and it was consensual. Maybe they had no sexual contact. But
Correct.
None of those things are negligent sexual contact. It's hard to have negligent sexual contact.
I don't agree, Your Honor. I think not. I think consensual sexual conduct, which is consensual at the time, which one party later determines she's not happy about it, and there's a fiduciary duty, which is what the claim is here, then I think in that case that would be negligent, or that would be.
No. I don't see how it's negligent. Meaning, what's negligent about consensual sexual contact that wholly unrelated to you later someone regrets? I don't understand.
I think the negligence, it's for a jury to determine whether under the circumstances he should have done it, they should have had sex or not, because she now says I was unwilling.
Wait. I'm sorry. I don't understand what's negligent. The negligence is, oh, a person taking due care would never have had sex with someone who might later regret it and make a false allegation?
Judge,
how are you supposed to figure out who those people are?
I'd rather not. If you disagree with me, fine. I'd like to move on to the false imprisonment.
Okay, let's do that. That seems like the hardest one.
There are roughly 15 or 20 paragraphs which implicate false imprisonment in the underlying beginning of the complaint, and those are set out in our brief in chief, I think on pages 12 to 19. And what the allegation is, and if you look at not only the complaint, but the underlying therapy records and other documents, which it's our position the defendants had a duty to inquire into and investigate into, the claim is that Mr. Marculetiu spirited her away because he was in love with her and she was afraid that she would never get home. And she was afraid for her life the entire time, and that's why she didn't flee. So a lot of the case relates to this claim for false imprisonment, and false imprisonment is specifically insured against under the personal injury provisions of both policies. So we have a case where there's a specific insured provision and specific exclusions, and they're fighting against each other. And the standard in the law relates to cases with mixed provisions, some of which are covered and some of which are not covered. And there is general rule in the law that an insurer must defend all claims, even if some are covered and some are not, until it's determined that none are covered. And I would like to cite some cases. Norfolk and Dedham versus Cleary, which I've cited at pages 40 to 41 in the main brief. Live by the Park, which is not a Massachusetts case, in page 41, involving assault and battery and false imprisonment contemporaneously, such as this. That's page 41 of the main brief, and First Specialty at page 42 of the main brief. And those cases say that it's not up to the court to make its own judgment as to what's the primary focus of the complaint. And I think that's the problem here. Going further, there are a number of cases that says insurer has a duty to investigate beyond the four corners of the complaint. And that's the case here.
Isn't that the only the case where the complaint itself is not clear on its face?
No, it's not, Your Honor. I direct you to Open Software, which is in our reply brief at 11 to 12. That's not a Massachusetts case. And that case said that there must be an unalterable determination as to the nature of the underlying claim.
Okay, but why don't we look at Massachusetts cases? And Boston Symphony seems to try to draw a line in terms of, just because you tell facts to the other side doesn't put them on notice. The touchstone remains the complaint, but where the complaint is unclear about what it's really alleging, you can look behind that at the underlying facts. Isn't that?
In this case, the complaint had referred to a letter from IBAN's attorney saying that there was nothing to this, that he rejected it entirely. Furthermore, 6 months or more before the complaint, Lissa Curtis was in therapy with Ellen Ronca. The allegations that she required therapy were in the complaint, and the Ronca notes mention, for example, rape versus sexual assault versus affair. Ms. Ronca was questioned about that. That's in the record. There's clearly a question of whether this happened, whether it was vengeful, whether it was false imprisonment, whether it was rape, or whether it was nothing.
Can we turn actually to the breach of trust or fiduciary duty claim? Because there you read it in its best light, your argument appears to be that at least if you know the underlying facts as laid out in the depositions, there is an underlying claim here that even if the actions of your client did not constitute actionable rape in the criminal sense, that it could rise to the level of sexual harassment, breach of trust, abuse of authority, for which there may be civil liability, for which there may be coverage under one or both policies. And is that in fact the argument you are making?
Absolutely, and I believe the Norfolk and Dedham versus Cleary case involves a sexual harassment claim, and there was an exclusion in that case, and the court held there was a duty to defend because there was still potential liability within the four corners of the insurance contract. Another case I would cite, Your Honor, is Judge Young wrote a case, Cohn, C-O-H-N-E versus Navigators. It's page 12 of the reply brief. And what he said, that was a case of an assault and battery by a bouncer. The question was it self-defense? And what the court held that the insurer's duty to defend is not determined up front. It can't be determined until after a trial on the merits.
Actually, isn't that what he said about the duty to indemnify, not the duty?
Well, but that relates back to the duty to defend, Your Honor, because it's basic law that the duty to defend is broader than the duty to indemnify. So if it's later held that there's a duty to indemnify, of course there was a duty to defend. So by foreclosing that, the court has prevented the insured from engaging in its rights. I see my time is up. If I could make two quick points, Judge, and I apologize. There is a provision in the safety policy, which is the governing covenant on the duty to defend, and it's at page A109, and it says, quote, "Our duty to settle and defend ends when the amount we pay for damages resulting from the occurrence equals our limit of liability." The national casualty policy, on the other hand, at 167, 171, and 183, says, quote, "However, we will have no duty to defend the insured against a suit seeking damages to which this insurance does not apply." I would submit that's a big difference. And the fact that safety did not say that is something for the court to consider in terms of the insured's reasonable expectations.
Okay,
Finally,
well, we have your brief and your time has expired.
I apologize, Your Honor. Could I just raise one quick point? And that is pages 178 and 183 of the first appendix relating to coverage territory. It's our position that the phrase that I've cited in my reply brief, which is the insurance applies only if the wrongful act takes place within the coverage territory, the activities of a person whose home is in the territory, which is the US, but is away for a short time on your business, which is what happened here, provided the insured's responsibility to pay damages is determined in a suit on the merits, which means that
Yes,
the
look,
only way the
Mr. Grumbach, we have your brief and we have that argument. And
Thank you, Judge.
if there are
Thank you
no
all.
other
Your Honor.
questions, are there
Sit down now.
any questions? No? All right. Thank you very much, Mr. Grumbach.
Thank you.
I don't know who's going first here. Is it Ms.
Sharon
Angelino?
Angelino for National Casualty Insurance Company. May it please the court. I would first like to address an argument in the appellant's brief that the holding in Worcester Insurance Company versus Fells Acre is the notion that sexual assault is inherently intentional, that this is limited to sexual assault of a minor. There has been no such pronouncement by Massachusetts court, nor has counsel identified any such pronouncement. Even if the court were to hold or find reasons for limiting the holding in Fells Acres in that manner, we would argue that the alleged victimization of Ms. Curtis bears many similarities to the victimization of minors. And specifically, Ms. Curtis considered the appellant to be a mentor. She thought he was looking out for her best interests. By virtue of the fact that he chaperoned her out of the country, he exercised a degree of control over her person and her whereabouts.
Counsel, why aren't you building a case for the viability of a breach of trust claim?
Well, the breach of trust claim would still be subject to the policy's exclusions. With respect to coverage A, the bodily injury and property damage coverage, we have cited to the sexual abuse exclusion. And we disagree with the determination of the court below that the exclusion is ambiguous in this context.
Because of the Illinois?
Because of the Illinois in the title. And under settled principles of insurance contract construction, one needs to look at the policy and read it as a whole. And in addition, consideration has to be given to the purpose for which the policy was intended.
Okay,
Here,
Counsel, time is short. Assume we don't agree with you on that.
well, I would just like to add that there are several Illinois specific endorsements in the policy. And the notion that they were intended to apply only to member organizations located in Illinois versus all the other states seems contrary to the purpose of this policy. It was a master policy. Its terms and provisions applied to all members.
And why does it say Illinois? Why isn't it just a term of the insurance?
Because the policy was issued in Illinois to an
Sure,
Illinois insured.
all of the provisions of the policy were issued in Illinois, but some of them say Illinois on them.
They're simply Illinois versions of those particular endorsements.
Can I? Well, no, I'm going to let you. You can keep going. I'm sorry.
Okay. To Justice
Can I ask you,
Milkey's-
actually, let me ask you, what's the difference between the Illinois sexual exclusion versus the one on 2 pages before? Any claim or suit arising out of undue familiarity, sexual abuse, or licentiousness, immoral or sexual behavior. What's the difference between those two?
Well, the undue familiarity exclusion is part of the professional sports, or I'm sorry, the sports professional liability coverage of the policy.
Okay.
It's in fact broader than the sexual abuse exclusion.
Can I ask
So
you a question? I'm a little bit more interested with respect to your sister and her policy. Why do you insure against false imprisonment?
Well, in this instance, I believe that we don't
I
insure.
understand that, but the insurance policy does insure against false, maybe not this. Why do you insure against false imprisonment? All these intentional acts are not insured against. And then there's this list of criminal acts that you insure against. Why? What are you envisioning there? Do you know? Why would an insurance policy say that?
Well, that's standard in coverage B, the personal and advertising injury coverage that is afforded under a CGL policy.
Why?
I assume it's because of the shoplifting scenario, correct?
I would agree with that analogy.
I guess this is for sports. What is it? Sports clubs?
Yes, amateur sports organizations.
And when do they commit false imprisonment that you want to insure against?
I suppose there could be an argument that someone was kept in a gym against their will during a practice
An argument called
session.
kidnapping. Right? I mean,
Well, if it's an adult, it's not necessarily kidnapping, but
you can kidnap an adult.
well, you can, yes.
You
Yeah,
go to jail for 20 years, but you can.
Yeah, how are we, as an appellate court, supposed to determine if the false imprisonment claim is bound up in the sexual assault allegations? And even if it is, why isn't there at least ambiguity about coverage where the policy expressly says false imprisonment is covered and the exclusions don't apply?
Well, our argument is that the false imprisonment was specifically alleged to be part of a scheme to isolate and victimize Ms. Curtis. So it's inseparable from the sexual assault.
Those are not quite the same, right? The way your brother put it is he had been in love with her all this time and he was holding her prisoner. And it's true that while holding her prisoner, according to the allegations, he sexually assaulted her in these ways. But if you read her claim about false imprisonment, it's pretty broad. It includes the side trip to his parents' house, the trip to the other, whatever they are, coach's house, and that dinner. Not every place they went while she was falsely imprisoned seemed to be for sexual conduct in the allegations. Obviously, I don't know what actually happened.
Well, even if we consider the false imprisonment to be a severable claim, there is another premise here that needs to be addressed, and it goes to Justice Milkey's point earlier. The appellant is only an insured under the policy in his capacity as a director, and for those actions which are in furtherance of his duties as a director.
Is that spelled out with precision? Because what I heard your brother arguing is, if you go to the contract, it says that you have a duty to defend the officers and directors.
You can answer the question.
It goes to the definition of who is an insured. And the policy is very specific that if the organization is a corporation, its stockholders, directors and officers, are insureds, but only with respect to those actions which are in furtherance of their duties as officers or directors.
All right, your time has expired. We gave your brother a little extra time. Do you need a minute here, or you think we have?
I think you have my argument. Thank you.
Thank you very, very much. We will hear now from you, Attorney Austin.
Thank you, Your Honor, and good morning to everyone. My name is Tanya Austin. I represent Safety Insurance Company, the appellee. I want to jump right into the false imprisonment argument, because I think one of the points that Your Honor's made earlier was, well, why isn't false imprisonment covered when it's, potentially in furtherance of the sexual assault? And I would argue that looking at the false imprisonment claims and the entirety of the complaint, the false imprisonment wasn't just in furtherance of the assault, it was the result of the assault. The false imprisonment count says Mr. Marculetiu confined the plaintiff with direct physical force and implied threats of physical force. And looking at all the allegations, it alleges that he pinned her, he groped her, he touched her unwantedly. All of those are separate sexual assaults. And by those acts, he created the fear of leaving, her ability, she was unable to leave. That constituted the false imprisonment. So in other words, the plaintiff is alleging the false imprisonment was effectuated by the multiple assaults. In that situation, they are so inextricably intertwined, you can't separate the false imprisonment from the non-covered assault.
Even if you're correct that they're somehow bound up in each other, why isn't there still ambiguity as to whether or not a false imprisonment claim is covered? Because you have one provision that says expressly false imprisonment is covered, and then you argue, but sexual assault is not. And you're saying, well, the result obviously is that the exclusion applies. But I'm having a hard time seeing, given that ambiguities are read against the insurer, I'm having a hard time seeing where your argument goes.
Well, I would say that Bagley versus Monticello instructs the court to look to the underlying facts that are the source of the liability and not the way that the complaint characterizes the liability. So in this case, while there's a claim for false imprisonment, at least a good portion of that false imprisonment consists of him holding her down while assaulting her. And I think we can all agree that's clearly not covered, even though theoretically, false imprisonment is something that's covered under the policy. And again,
she thinks he's going to do something, according to her complaint, I don't know what, to prevent her from returning home. I mean, that sounds like kill her, but I don't know what it means exactly. But sexual assault doesn't, that's not every way, apparently, that this alleged false imprisonment is supposed to have been effectuated.
Well, respectfully, Your Honor, I disagree. It's not just the sexual assault, the act of rape. All the discussion, the things she references in making
groping, all of that stuff. But she's afraid, if I'm reading her complaint correctly, that if she doesn't play along with this, he's going to do something terrible to her to prevent her from returning home to the United States. Right?
But the reason she believes that is because he's been physically intimidating.
Well, I agree that may be, yes, I agree that may be what gave her the hint that he'll stop at nothing. But I'm not sure it's the same. Can you answer the question I had for your sister? Because it seems a little more mystifying to me here. This is a homeowner's policy. What false imprisonment claims do you think are covered?
Well, I would point out that false imprisonment can take many forms, as Mr. Grumbach had pointed out in his brief. It doesn't have to be physically holding someone, hostage. It could be giving someone the impression they're not permitted to leave. I can certainly envision a situation where a babysitter was there and, was in the home and felt she was unable to leave because of some conduct by the homeowner, which wouldn't necessarily be the kind of violation of penal law that would fall under the penal law exclusion that's contained in the policy, which we also addressed in our brief. So it doesn't have to be, a false imprisonment, like a physical holding hostage with weaponry.
You think that's false imprisonment? Telling your babysitter that you have to stay because the baby's still crying?
I think technically under the definition that by a counsel, yes, it would be. I don't think it'd be a valid claim, but it would be something that would be alleged in a complaint that someone would want a defense under. Now, going on.
Let me ask you about that criminal penal. I didn't ask your sister, but I'll ask you. What penal law was violated here?
Well, I think as you pointed out, you can in fact kidnap an adult. I believe sexual assault.
And under what law is that? Under what statute is that unlawful in Romania?
I knew you were going to ask that, and I don't have an answer for you on that one.
Why not? Why don't you have an answer? I don't understand. You say it's a penal law, and I look at your papers and your sisters in vain for any reference to what penal law exactly. I mean, I assume kidnapping is illegal in Romania, but why haven't you told us? I mean, I don't mean to like castigate you like that, but I'm left thinking if there was an obvious law that was violated, you'd have told me.
No, you're correct, Your Honor. I don't have a citation to Romanian law as to when rape would be a violation of its criminal code. I think that arguing otherwise.
Well, false imprisonment is the one that's harder, right? Rape, there's a million different ways maybe that rape isn't covered. False imprisonment, I don't know.
False imprisonment by means of rape, I think, would still be a violation. And that's what's alleged in the complaint. Again, we're not looking at what Mr. Marculetiu was claiming happened. We're looking at what the plaintiff is claiming happened. The question is, if he's found liable for these things, are those covered? And I think Judge
Counsel, in our limited time left, can we turn to the breach of trust claim? Because the argument that the plaintiff here is making is essentially that it relies on the statements that the plaintiff in the underlying case made with respect to what happened in Romania. Let me ask you, start with this question. Could someone be liable for an underlying tort under these circumstances if the jury concluded there was no rape as such? By that, I mean based on a sexual harassment or breach of trust kind of theory. He abused his authority.
I would say that if that were possible, that kind of claim would be excluded under the business exclusion applicable to personal injury. Because if Mr. Marculetiu had some position by which he was required to have some position, authority over her, that could only spring from his position as her ballet instructor, which, as Mr. Grumbach.
Why? Like, don't we all as human beings have a duty not to take advantage of a superior position of authority?
But that position of authority arises out of his business. So I would say it would be excluded. The court never found the occasion to reach that because it already found that there's no underlying covered claims. So the business exclusion wasn't reached. But I would say that had it been before the court in a way that the court had to reach it, it would have been barred. Now, honestly, the bottom line is that no homeowner reasonably expects that his policy will cover him for claims of repeated, forcible, and intentional assault and the consequences of that assault, regardless of how those claims are characterized legally. I ask you to affirm the trial court's allowance of safety's motion to dismiss.
Now, just for clarification, you don't appear to be arguing that there's any kind of extraterritorial coverage issue with regard to the homeowner's policy. Is that correct?
I have not argued that in my motion.
Okay. Thank you very much. This is a complicated case, and the three of you have done an excellent job and obviously know it forwards and backwards far better than we do. So thank you very much. It's very helpful to us. The case is submitted.
Thank you, Your Honors.
Thank you, Your Honors.